Welcome back to another episode of the Vet Worthwhile podcast. I am James Yost, partner and wealth advisor at Signature FD, and I'm joined as always by my co-host Travis York, owner of 3-1 Advisors. Travis, how are you?
I'm doing great today, James. How about yourself?
I'm doing well. Welcome back to another episode of the Vet Worthwhile podcast. As always, you got James Yost and Travis York here. Thank you for listening. This is our third episode of a 3-part series, specifically diving into the hot topic of employment agreements, non-competes, non-solicitation agreements. Travis, who do we have today to guide us through this discussion?
Today, we are going to tap into the legal expertise of the team at Mandelbaum and their National Veterinary Law Group. And Peter Tanella and Brent Pohlman have been gracious enough to join us. Peter has years of experience on the transaction side and is going to provide us some insight into what to expect as the non-compete issue plays itself out in the transaction. And I guess transaction is probably a little unfair, Peter, because you really have built your practice around just being a general guidance and a business partner for all of your clients over the past 20 years. So it's wonderful to have Peter with us. And then one of his partners, Brent Pohlman, who focuses on employment law, is going to join us probably to talk, Brent, maybe a little bit more on the technical side of the non-compete.
Yeah, we're going to kind of explore the scope of restrictive covenants in the current climate, what practices have available to them now, sort of what changes we may see, and how we can respond to those changes.
I'm super excited to dive into this and really, first and foremost, excited to have you guys here to be a part of this, because I think your information and what you've seen is going to be incredibly insightful. And Brent, as you point out all the time when we talk, it's not non-compete, it's restrictive covenants is really the correct way to reference it. So maybe that's just a great place to start. Why do I always say non-compete and then you always have to jump in and correct me that it's restrictive covenants?
No, that's a great question. Everybody always presumes, they always think that it's the non-compete agreement is the tool that's out there. And in fact, that gets used very broadly. But, when we talk about protecting an employer's business interests or practices interests, that can be done through a variety of what are known as restrictive covenants. And restrictive covenants are agreements that parties make, in this case, either a buyer and a seller, an employer and employee, an associate who's coming in acquiring equity. They're agreements that the parties make that says that I will not do the following either during or upon the dissolution of our relationship. And the following includes such things as a non-competition agreement. And a non-competition agreement would include a geographic area and a period of time and a type of work. So it could be general veterinary work within 10 miles for 2 years. A non-solicitation agreement. Non-solicitation is then broken down into 2 separate parts. There's non-solicitation of employees and non-solicitation of clients. And in some states view those differently, of finding that a non-solicitation of prohibition on solicitation of clients is more likely to be enforceable than a non-solicitation of employees. Then there's also a confidentiality agreement, which is sometimes referred to as an NDA, but that's not entirely accurate, because an NDA can be a non-disclosure agreement and or a non-disparagement agreement. And then one other item that we're going to probably talk about during the podcast today is the idea of restricting a former employee's ability to engage or provide services to clients, which is a little bit of a step above a non-solicitation, but a step below a non-competition. Those are our components of the world of restrictive covenants.
No, that's super useful as we get started on this conversation. But to kind of dig in a little bit deeper here, would you be able to help our listeners understand from a legal validity perspective and like an enforcement perspective how the restrictive covenants work in a couple different scenarios? One is in a traditional employment agreement. So if an associate is getting hired onto a practice, the second scenario being when they're added in as a minority shareholder, like if there's restrictive covenants in an operating agreement. And then the last one we'd like to look at is restrictive covenants associated when a doctor sells their practice. So maybe one that's entered into with a buying entity. So can we kind of partition those out and lean into those a little bit?
Absolutely. So we'll start with the non-competition agreement that's ancillary to an employment agreement. Now, we have to always caution this with every state right now is different. There is no federal guidance on this. I'm sure we're going to talk later today about what's going on at the Federal Trade Commission, but right now this is governed on a state-by-state basis. And so we're going to talk in generalities right now, but each state does have slightly different standards. Some states, a non-competition agreement is completely enforceable. In others, there's limitations to it, and in others, they're prohibited. So generally, though, in states in which a non-competition agreement is legally permitted, it will be enforceable in the context of a term in an employment agreement if it is legitimately related to a legitimate business interest of the practice. And, we're also going to start with this, right? We call them non-competition agreements. That's sort of the term of art that we use and how they're casually referred to as that. But it's funny because in actuality, the courts will say, listen, we don't really encourage non-competition agreements to be anti-competitive. It's to protect businesses' legitimate business interests, which it's an interesting balancing act because the general rule for contract clauses and government enforcement of same is that they're not going to enforce something that's strictly anti-competitive. So it has to be shown that the main purpose of this isn't necessarily to suppress competition, but to protect the legitimate business interest of the employer. And in the context of the veterinary world, that's obviously the client relationship, the goodwill that's developed with the clients, and the reputation within that professional or geographic community.
I have a question on that one, if I could briefly just jump in. So just thinking through that, because obviously it's up to interpretation and fairly vague, which one of those two things we're brushing up against. But if a government agency was looking into it and trying to figure out whether or not it was enforceable, if you had a situation where the original owner had excess demand and wasn't servicing people well, and then tried to shut down their former associate from starting a practice when there was a ton of demand for it, would that be kind of an example where that's really monopolistic in the area because there's clearly a demand in the area for different services, or how does that work?
So the courts aren't going to look at sort of the facts of supply and demand and whether or not that particular market needs the services. They're going to look at it from the perspective of what is the restriction prohibiting and how much is there still an opportunity for this employee to work in their profession and earn a living, right? Mm. And that's why in the veterinary world, we look at non-competition agreements in terms of what's being prohibited and the period of time it's being prohibited for in the region it's being prohibited in. So we'll start with the first one as far as what's being prohibited, right? There are different types of practices. There are specialty practices, there are general practices, there are emergency care practices, and there are urgent care practices. A general veterinary practice that has a non-competition agreement that excludes the complete practice of veterinary medicine within, a 30-mile range is not going to be enforceable in most states. Because if you have a specialty, well, you're in that practice isn't a specialty practice, you're not competing with them. You're not interfering with them. They wouldn't have a legitimate interest in expecting you not to be working in that specialty if it's not something that they offer. If they don't offer urgent care or emergency care, they wouldn't have a reasonable expectation that an employee should be excluded from working in those areas. And that's why it's very important for both the employer and the employee to clearly identify what it is that is being excluded or what we're agreeing not to do in terms of the non-competition agreement. Because if it is not specific, it's not going to be enforceable.
I was just going to ask on that, kind of comparatively speaking, right? Because I've heard people say, oh, well, okay, you go from an employment agreement to now you have a minority interest. We've got a lot of, minority shareholders. And then that gives the ability to expand the restrictive covenant. Or if you sell, then the expansion of that restrictive covenant may become even greater. Is that sounds like I'm kind of hearing from you a different interpretation of restrictive covenants, which at the end of the day, restrictive covenants are just designed and supposed to be legally in place to protect the business at hand. Can you kind of help clarify on that a little bit for me, Brent?
Yes, I was providing some detail with respect to the employment agreement. As we move on to restrictive covenants that are ancillary to an equity interest or a purchase agreement, they're going to be more broadly interpreted and enforced. Now, the action that is going to be prohibited still has to be connected to what the business does. If the business is an equine practice, prohibiting whether or not you're a minority interest holder or you're somebody who had sold pursuant to a purchase agreement, a non-competition agreement that keeps you out of the veterinary industry as a whole within that region isn't going to be enforceable. Where it changes, where it steps up from employment to equity holder to seller is in the length of the enforceability and the mileage. So generally throughout most states, now I'll say generally because some states are down to 12 months, some are 18, but generally a restrictive period of 24 months has been determined to be enforceable for the veterinary industry across the country. Again, in those states where it's permissible, absent some having specific statutes or regulations. Now, when we look at somebody who is now an equity holder, that 24 months is going to be increased. And, it wouldn't be unrealistic to see something at 30, 36, 42.
Now, can I ask a question on the equity holder side of things, Brent?
Yeah.
Let's say you and I own a business and we're 50-50 partners, and inside of our operating agreement, we each have a 36-month, 20-mile non-compete. What happens if you become a 2.5% owner and I'm a 97.5% owner? Are we both equal to that? Like, are the restrictive covenants applicable to both of us, even though that my one minority shareholder is only at 2.5% because they have an equity stake?
So that's a really good question. And that's an area of the law that's been developing. And I think we're going to see more development in if there are greater restrictions placed on employment-based non-competition agreements. Because right now, there are not a lot of decisions that analyze sort of I'm going to use the word equity, but the equity in a restrictive covenant in an equity agreement is in how much equity do you have to have before it's considered that this enhanced restriction is enforceable. Right now, the guidance that we're providing is that it should be reasonable. That certainly, if you're an equity holder, if you're receiving a profits interest, if you're receiving distributions, you are getting certainly compensation in exchange for these restrictions that you're agreeing to. So, that box is checked. The question as to whether or not you could then go to a 5-year restrictive covenant off of only having a 2% interest. I don't know that I want to be the first person to have to defend that or to have to litigate that issue. I think that certainly it's going to become a fact issue that's based on the amount of money that one's generating. If you're seeing some, additional income in exchange for this equity interest that you receive, there's going to be a real strong argument that it's enforceable. It was an arm's length transaction. You didn't need it to, maintain your employment. It's separate and apart from that. You chose to become a member of this LLC. You chose to become a shareholder. And this is something that you had to agree to in exchange for that. Now, like I said, is it going to be lifetime? Never. 10 years? Never. I mean, we're going to get into the upper realm of enforceability of time is really that 60-month or 5-year window that, we most often include in our purchase agreements.
Well, and what really gets interesting for me on that, Brent, and again, I want to keep us moving because look, man, we could go down a rabbit hole and stay there for probably the next 3 hours and bore our listeners to death. But, it's so interesting to me that it's like not, look, 2.5% interest, a 2.5% interest in a hospital that has $10 million of, profits is vastly different than a 2.5% interest in a hospital that has $100,000. And kind of what I'm hearing you say is the courts may look at that and say, hey, you didn't have to sign that to have your employment. And what we're really focused on is protecting the right to work. And so that may have been just a bad business decision on your part.
Yeah, that's the argument that's going to be made. And frankly, I think a lot of courts are going to view it that way. Now, we would still always recommend that it be reasonable, that it be related to the benefit that you're receiving. But there's also, when you're getting involved and you're receiving equity, there's the idea that could grow, that you could be acquired, that could turn into something else. And while it may be, 2.5% of $1 million gross revenue in 2023, when you receive it, you're getting into that with the idea that where is it going to be in 7 years from now and 10 years from now? And again, because you don't need it, it's not being required to maintain your employment, the courts are going to look at it much differently. And it's going to be analyzed under the context of you assumed this obligation in exchange for this opportunity, and that was an informed arm's length decision.
And we'll maybe jump on from this, but do you mind, just for kind of our listeners, when you say informed arm's length decision, in layman's terms, what does that mean?
So when the courts look at the enforceability of contracts, everyone always assumes what's on the paper is the way it's going to be done. But courts do try to be equitable, and they want and when there is inequity in the balance of power in negotiations, the courts will take that into consideration in determining, how is this term fair? Should it be enforced, or was it coercive? And sometimes there have been entities that will issue employment agreements and in which they'll force people to sign them immediately, and it changes the terms and conditions of their employment. They have the opportunity to review it. They have an opportunity to have a lawyer review it. And the courts will look at this and say, these people would have lost their paycheck and you didn't give them any time to review it. And I'm not sure that some of these punitive or more restrictive terms should be imposed. Now, if I'm a doctor who's employed at a practice and I'm offered the opportunity to become a shareholder, a member, and I'm given the operating agreement, I'm given my purchase documents, I'm told to have my attorney review it, there's negotiations, and after that whole process, I end up as a 2.5% interest holder, and I've agreed to the terms of the operating agreement. Well, the courts are going to say, you're an educated person, you had the opportunity to review this, you had the opportunity to negotiate over it, and after doing all of that, you agreed to this. We're going to find that you're going to be bound by it because this was a informed decision that you made with your own volition and with the assistance of your own counsel. And so, going to the court and saying, "Oh, it's not fair. I want to get out from under this." Most courts aren't going to be receptive to that argument under those circumstances.
Yeah, no, I just had one other thing to add on that. And Brent, and putting it in practical terms too, how many times do we have clients come to us, associates who come to us, and they have a really poor, employment agreement that was provided to them by maybe a corporation, and the mileage is what we would probably say unreasonable. It may be 20, 25, 30 miles. It's a small animal practice. I mean, from a practical standpoint, we typically, I'll tell them, the likelihood of this being enforceable is probably very minimal, but it's very difficult for that associated to push back on it because you're dealing with a large corporation with deep pockets. I mean, we have a scenario right now with a client who's looking to do her own venture with a partner, but because she signed such a poor employment agreement with a big corporation, she she's got a really difficult decision ahead of her, whether or not she wants to challenge that, even though she probably had an opportunity to have counsel look at her to review it. It's not like a one size fits all in that circumstance, unfortunately.
On that though, can you talk a little bit about how you guide your clients that are hospital owners on this? So from my perspective, you're juggling the interpretation of the validity with respect to the employee who signed versus the actual in-court validity of the agreement, plus what's fair and reasonable, So when you guys are working with clients and they come to you and they're in a metropolitan area with a small animal hospital, how are you advising them to set up their employment agreements?
Brent, if you don't mind, we just answer that quick, and you can piggyback off of it because we kind of work in tandem on these. Brent said the word on several occasions. It's reasonableness. You kind of take the approach. It needs to be reasonable. And James, you nailed it on the head. Where are they located? Are they in New York City, where it's going to be several block radius, one to the west or the east? Or you're in the suburbs where you're going to have a larger radius, and it just depends, and it's not a one size fits all. And I think a lot of clients come to us too many times, and they're very they don't put a lot of credence to it because they're like, it's not enforceable anyway. And then we say, yes, they are enforceable, again, depending on where you are, as Brent pointed out, but provided it's also reasonable. We have a lot of clients who say, we want 25, 30, 35 miles. Well, you can certainly put that in there, but it doesn't, you're going to run the risk of it being challenged. So it is a balance, and we try to educate our client on what they're doing, what type of practice it is, and the risks that involve, and kind of talk them through that so they can make an educated decision, and then we can draft accordingly.
And so do you do the same thing? So in the situation you just mentioned, had your client, I'm going back to the one where you talked about the client who's starting up their own hospital with another partner, so had you all been advising her when I think it was a female, when they took on the job at the old practice, would you have said, hey, this is a very, very long, we need to hone in on this range. This isn't reasonable given your life. So is that also kind of custom tailored to their specific situation? Or are you saying, hey, don't sign one or push back on all non-competes? What do you guys say when you have a client who's being proposed or presented with the agreement?
Okay, there's multiple factors involved, and you want to obviously counsel them, tell them what the market is. It's also going to depend on what leverage you have. Now in her situation, when she signed on with that particular corporation, maybe she needed that job and she's willing to do it. She's not looking down the road to some future business venture. We're always asking them, where do you see yourself in 3 years, 5 years, 7 years? Because we need to understand, we want to have a better understanding where you are going to be, so then we can advise you accordingly and let them know, okay, well, if you do sign this, this is the risk that you're going to be running if you go ahead with this type of term or radius. I guess the easiest way to explain it, it's not a one size fits all. And I think too many clients feel that it is. It really needs to be tailored to whether or not you're the employer, the practice owner, or your associate. You're buying in, you're getting equity. It's a conversation you need to have with your client to understand what their goals are, so then we can draft accordingly around it.
Whether it's the employer, the practice, the clinic, or the doctor, I always take the approach that the best thing that we could do is provide certainty and avoid problems down the road, avoid litigation, right? We've done our job. If everybody is clearly aware of what their responsibilities and their obligations are, they're comfortable with them, they understand how they work, and that having those will enable both parties to go forward together or separately and achieve their professional goals. And, as Peter said, from a hospital point of view, we have clients that come and say, I want to impose the following. I'll tell them that's never going to be enforceable. That range is just unrealistic. Sometimes, listen, you can give clients advice, both doctors and hospitals, and if they choose to listen to you, they do. If they don't, they don't. But what we try to do is say, we want to create a document that's going to work for you now and into the future. And, as Peter said, right here where our office is, we look to the east and we see Manhattan, where we have a radius of a few blocks. Out in the suburbs, we look at your traditional, 7.5 to 15 mile radius. And then I drive in from horse country every day where, you could have 20 plus. And you have to look at the specific facts of each situation and of your state and determine what's going to work. And, it's an interesting question you asked. So what do you tell the doctor? So, we recently had an issue where there was a corporate entity that was bringing on a doctor, and it was in a more metropolitan area. And they had a restrictive covenant mileage range that frankly, I didn't think would be enforceable. And I wasn't saying that because I was representing the doctor there. If I was representing the practice, I would have said, guys, I don't think this is going to be enforceable if anyone ever challenges it, given the scope of that distance for a metropolitan area. And in negotiating with the counsel for the employer, they said, well, this is just what we do. We can't change it from practice to practice. That's our standard. And one, that's just not correct, because the law tells you that you should change it from practice to practice, that it should be tailored to what protects the legitimate interests of that practice. And that's when the client said, I really want this job. I need this job. What do you think? And I said, well, this is a difficult decision, because I'm going to tell you that anytime you sign your name to something, you have to be prepared for it to be enforced. But I'll also tell you that I think this particular state is going to have a very difficult time enforcing this type of geographic range, because it's not going to be reasonable for that location. And as Peter said, sometimes people have to make, both practices and doctors have to make decisions on what their needs are at that time. And, I had some clients who said, I'm not going to sign it. And others who said, you know what, I appreciate your input. I'm going to take this job now, and we'll see where we are in a few years.
Brent, in the event they don't want to take our advice and they go ahead and they make a broader radius or they make a longer term, so the listeners understand, what's the risk that you run? I know we keep talking about court or, running into court. Maybe you could touch briefly on the blue pencil and the control that you lose as the practice owner or even the associate in the event that it's an overreaching restricted covenant, which is another thing that we always try to avoid.
So that's a great question. So what we talk about, well, what's the risk? Let's see, how does this come up? So a doctor leaves a practice and goes to work somewhere else, and within that the restricted geographic territory. The practice then has to make a decision. Are we going to pursue legal action to get an injunction or an order from the court that tells this doctor they can't work at that location? They have to make that decision. They can invest the money, or do they think their position is strong enough? Now, let's say they go forward and they do impose it, or they do seek that injunction. They're going to go to court and they're going to say, Judge, we want you to issue an order that stops Dr. Jones from working at ABC Medical Practice because it's within a 25-mile range. Now, the court's then going to analyze it, and the doctor is going to argue, hey, this 25-mile range is unreasonable for the following reasons. It doesn't protect their legitimate interests. It's just meant to stop me from working. And the court can say, it depends on the state you're in. In some states, there's a standard, a legal concept known as the blue pencil standard. And what that means is that the courts have the authority to redraft, to change the terms of a contract to make them either compliant with the law or equitable. So in a blue pencil state, the court could say, boy, I agree with you. This is a major suburban area. There's 1 million people who live within this county. A 25-mile prohibition is not protecting your legitimate interests. I'm going to lower it down to 5 miles or 7 miles. And so you run the risk that the court's going to, in those states, that the court is going to reduce the restrictive range to what it determines to be fair. Now, a lot of courts don't like telling people that they can't work somewhere. So when you rely on the court to make that decision, if you're going to say, well, I'm going to have a larger geographic range, and if the court makes it smaller, it does, so be it. They could make it 5 miles. They can make it 3 miles. You don't know what you're going to get, what that judge is going to determine is appropriate. Then the other side of the coin is some states are not blue pencil states. And in some states, if a material term of a restrictive covenant is determined to be invalid, then it's void and it's not enforceable at all. So you run the risk of, if you impose a term that's too broad and oppressive, you run the risk of there being no protection at all from the hospital perspective. And then the courts don't even have the ability to make it less. They find it's not enforceable, therefore it's void. And so that's why, we really encourage our clients to draft restrictive covenants that are enforceable. That's the first thing we're going to say. And then most of our clients will say, well, we want something that's fair too. And in your opinion, as experts in the field, what do you think is fair? And that's when we really look at the details of their practice and of the region. Because you don't want this to be left in the court's hands.
Well, and that kind of leads me to my next question. And, maybe I'll direct it, Peter and Brent, to both of you guys. Obviously, there's a lot of talk of, what you've talked about is the ambiguity, the unknown, and then it ends up in the courts, in the hands of the courts, and it ends up litigated and the stress and strain that causes, right? And in you guys' practice, you tend to try to drive to clarity and expectations that are manageable and probably not on the edge. Do you think, from your take, is the FTC going to come back and, find a place where they say, hey, we're going to have a blanket, guidance on non-compete so that they're the same in all states? Is this something where you think they just go away with non-competes? And is the real mission here maybe not for the FTC to look at removing non-competes, but to create kind of more concrete guidance for both employees and business owners?
Peter, you want me to jump in on that first?
Yeah, Brent, I mean, you've been talking about this almost on a daily basis now with our clients. Yeah, please.
So let me give everybody a little background, right? When the Biden administration came in, they raised the issue of non-competes from the inception of the administration. And the administration said, we want to look at this because we're concerned of there being inequities in the enforcement of non-competes and that they're being used unfairly and not as intended. And where that actually originally came from was there are retail businesses, including fast food locations, that were utilizing non-competes to prevent low-wage, minimum wage earners from working for competing franchises. And this also had the effect of creating wage suppression because somebody who was experienced as a manager at fast food restaurant A couldn't go across the street and say, hey, I've been running, A for 3 years, you want to give me 20% more to come here and manage your shop, right? And there was a real concern that large entities were using non-competes really in an anti-competitive manner, and we're suppressing wages and really impacting low-wage earners. And so initially, that's where the administration, what their talking points were. Then right at the beginning of 2023, the Federal Trade Commission issued their proposed rule on restrictive covenants, which are on non-compete agreements, which was far broader than that and proposes eliminating almost all non-compete agreements that are ancillary to employment agreements. And I'm going to stress that it's employment agreements only. It also would limit to a certain extent confidentiality agreements that were drafted in a way that would lock somebody out of a market or an industry as well. But that doesn't really come into play in the veterinary industry. So that was a big departure. The proposed rule that came out in the beginning of 2023 was much more expansive than what the administration had been talking about. Some people, I think it's myself included, suspect that one of the reasons that was done was so that when the final rule comes out, and if it's scaled back from that, it could potentially make both sides happy. Now, there has been a lot of feedback that's been provided to the Federal Trade Commission during the public comment period. In fact, so much so that the public comment period's been extended. I believe it's for another full 3 months. And so at this point, the earliest that we would see any final rule from the FTC would be October of 2023. I fully expect that come October 2023 or at some point in the winter or early 2024, we will get a final rule from the FTC that does have limitations on non-compete agreements. I'm not going to speculate as to what that's going to look like right now. I suspect it'll be somewhat less than a complete prohibition, but somewhat more than just the prohibition on low wage earners that was initially being talked about when the administration first took office. What's going to follow after that is litigation. There are going to be business entities and states that are going to file actions challenging the FTC's authority whether the FTC is engaging in proper rulemaking or if they're engaging in legislation through rulemaking, and whether they have the authority to do this. And that's going to take some time. But for, political reasons only, and small p, it doesn't matter which side you're on, for political reasons only, we could expect that going into an election year, that the administration is going to issue some type of rule regarding non-competes, and it's going to restrict them in some way. Whether that's going to go into effect next year or it's going to be enjoined by a court while this matter is being litigated, that's a question that we can't answer right now. But the FTC has certainly been a hot topic issue. Everybody Googles it and they see it and they say to themselves, there's not going to be any more non-compete agreements. We're not there yet, and we're kind of far from that. So right now, everybody should be operating in the world of they're enforceable if they are in your state. If you're in a state where they're enforceable, they're still enforceable. But let's also talk about what we can do in the event that they become unenforceable or void.
Well, let's talk about that a little bit. And I don't know if you all have clients in California, but we kind of look at them as the base case. And what I'm trying to get to is really on the transaction side. So if I'm buying someone's practice and I'm no longer able to enforce a non-compete, let's just say hypothetically they are able to kind of make them at least very, very rare, if not altogether abolished. What impact does that have on the value of that business? And so looking over to California, do you see valuation multiples down relative to the rest of the country? When they have to price that in, that risk in? That's a question for you guys. And then also in those cases, if you do have clients in California without employment agreements, are you seeing them more likely to go out and start a competitive practice?
Brent, you want to start off and I can chime in afterwards to talk about how we advise our clients out in California?
Yeah, absolutely. So we do work, and we do have clients who are operating in California. And obviously, there has been for years a statutory prohibition on an employer restraining anybody from engaging in their trade. And in fact, they even have restrictions on non-solicitation agreements in California, which, prevent anti-poaching terms and clauses from being implemented. It is an issue because it doesn't provide the seller or the buyer with the certainty that they need or they want, knowing that this seller, that this doc can go and can compete against them. That's where we sort of look at the specific, the law in California as it relates to non-solicitation of clients, and work to create terms in both the purchase agreement and in the subsequent employment agreement, if the seller's staying on, that are very tight as far as, soliciting those clients, the use of confidential information, and try to assist our clients out there to get the most protection that they can, given the statutory limitations or the prohibitions on having those restrictions. Yeah, interestingly, I will tell you, I have also seen a number of employment agreements in California that do contain non-compete agreements. They're not enforceable, but there are still employers who have included them, which I suspect is just for effect, to try to intimidate the doctor to not engaging in any type of competitive activity.
That's interesting. I wonder if they even, a lot of them even know that, it's just there and it actually works, even though there's no enforcement.
Well, if we take that a step further, and I mean, Peter, I'll probably direct this one at you, only because I know you do a lot of work with some of the lenders. How do you see non-competes not being available for employees impacting hospital purchases and hospital transitions, and people being able to access money to buy, grow, expand their hospitals?
Travis, that's a great question. It's something that our team, discusses on a day-to-day basis and try to come up with some alternate, if it were to go that route, and come up with some type of alternate solution in order to protect, the practices. as I sit here right now, and Brent, I mean, you and I've had hours of conversations on this. I can't see how you'd have just paint a broad brush and preclude non-competes in these practices. And I think, Brent, you nailed it on the head earlier when you talked about when you kind of broke it out into the various practices: small animal, specialty practice, emergency practice, urgent care practice. And we represent all those, and large animal and what have you. And each one has a different analysis. We have a number of emergency practice clients. And, that situation, I'm not as concerned. In fact, I'm not concerned really at all because, you're not developing any relationship with a client. Mm-hmm. But you can't have that same you can't paint that same brush with a small animal practice or a specialty care practice, because there are relationships that are being developed. And if someone were to leave, and that practice could be hurt. So
Can I ask a question on the emergency? Yeah. Are they completely removing non-competes? Do they have any non-solicitation related to going back to the hospitals that are referring business to the emergency? Are they protecting that at all? Or are they just saying, hey, Wild West, like people are coming in and we have faith in like our self-driven, business that we don't need either one?
I think the majority, Trav, and I say this because we have different clients doing different things. I think the majority you're still going to have some type of non-solicitation in there and just doing away with the non-compete. We do have clients though, and they're the bigger, larger, I guess can be more risk averse, who said nothing. You want to come work here? We're not going to tie you in anything. They feel that the benefit of working there is great enough where you leave, we'll deal with it if you leave because we have so many other people who want to come work here. So again, it's not a one-size-fits-all conversation. It depends on the client.
No, that makes a ton of sense. Now, and maybe this could be directed at Brent, but obviously we talked a little bit about lenders and, they'll probably have to react to non-competes and, maybe non-competes will go away completely. But at the end of the day, the goal is to protect the business, right? If we kind of shift our focus back to the general practice, it's really that client relationship. Do you see non-solicits becoming far more explicit and hospitals then relying and defaulting back to, and Brent, I can't remember what you called it, but basically restricting the ability to provide services to clients? And that's how you could not have a non-compete, but still effectively protect the business?
Yeah. So, let me clarify one point. In California, you can have a restrictive covenant ancillary to a operating agreement or a sale that's like that. I think the language they use is substantially all of the assets. You can't use it to in which if it's only a small percentage, but without the specific reg in front of me, don't want to misspeak on that. But even in California, transactionally, you can have restrictive covenants in place. And nobody anticipates that the federal legislature or the federal rulemaking is going to prohibit non-competes related to membership interests or business acquisitions or business dissolution. That's certainly not anything that we're anticipating at this point. But going back just to clarify that and go to your point, Travis, yeah, I think the world we should be ready for is in which, the general practice does more on the non-solicitation end to clearly identify and define within the employment agreement, who are the clients that this individual, that this doctor is precluded from providing services to, from soliciting, and for what period of time. So, let's say we said that, we define practice client, and we were to say for, anybody who is defined as a practice client for 18 months prior to the associate's departure. And they have no restriction on where they can open up across the street from you. But we put language in there that will prevent them from soliciting and providing services to these individual clients. Now, the difficulty with that is non-solicitation is hard to prove as it is, because it's so hard to prove, how did that subsequent relationship come about? And even, non-treatment, unless there's a transfer of records, somebody has firsthand knowledge, they're difficult things to prove. And in some jurisdictions, it wouldn't be enforceable. In others, it absolutely would. But that's the route that we're going to be looking to go, as once more states on their own limit the enforceability of non-compete agreements, and with the concern that the federal government may take action.
I have a question for you guys on, have you ever seen it bifurcated within an organization? So, for example, in the vet hospital example, like if someone comes in and is a customer of the practice in general, who was either referred from another patient or found us online or called in or looked on Google Maps, whatever, those would be clients of the hospitals. And then if, for example, a specific doctor is going out and doing their own networking marketing referrals from their existing clients, that those patients belong to that specific doctor. So then when they leave, they're not able to solicit clients of the company, but they're able to, take their existing practice book with them, so to speak. Have you ever seen that in the veterinary space? Because I know that's a type of structure that's used in other businesses.
So, Brent, I'll chime in on that. I have, James, on a very, very limited basis. And I've seen it more where it's a younger associate who maybe got an opportunity to buy into a practice, and then he or she's going to get a bigger piece of that practice and eventually buy that particular practice owner out, who may have some other locations. I've spent some time in the weeds negotiating those types of deals where, the senior doctor who's going to go maybe to another location and sell this piece off to his associate, they kind of go through a lot. Not only they go through the client list, among other things, and they kind of split it, because the senior doctor looks at it. He's given this person the opportunity to buy in and then eventually own the practice. But the senior doc feels that he's brought so much more to the table. He wants to be able to contact certain clients at his other location. It's very cumbersome, and it's happened on very limited occasions, but we have done it.
Interesting.
I mean, I think as this evolves, I'm really interested to see. So obviously, Peter and Brent, from you guys' situation, like almost whatever the ruling is going to create more ambiguity, which is going to create more opportunity for attorneys to get in there and litigate this on the back end, right? Like I almost see this as being like a booming opportunity. I wish I was an attorney who understood this stuff. But how are you going to guide your clients in this new landscape to avoid being in that situation, whether they own a hospital or an employee? It just seems like what I keep hearing you guys say is your best guidance is structure it in a way that you don't end up in litigation in the court system. And so then what do you, what do you do to avoid that going forward, especially given like the unknown in this interim period, right? Once the rules are made, we'll kind of know where to go. But like, how do you structure it today when the rules are unknown to protect yourself, but to not put yourself in a place where you're going to, arguably potentially be having to litigate something?
Brent, I can respond quick and then you can hop on in. I'll go back to that really simple term, reasonableness. It sounds really basic, but depending on what hat you're wearing, and we wear multiple hats, I think that benefits us too, whether or not we're representing the associate, the practice owner, someone, minority owner. You take the approach, what's reasonable, and you advise your client accordingly. So if you have the associate and he or she's looking down the barrel of a gun, and it's this 3-4 year term, and it's just unrealistic radius, you talk to them about it. You explain to them the risks that are involved, and then hopefully you're going to be able to talk with counsel on the other side and kind of bring it back into reality. And it just depends on its situation. And then you talk with your client, and if he or she's okay, I'm willing to, even though it's unreasonable, I'm willing to sign on anyway, because for X, Y, and Z factor, they're going to go ahead and do it. I really kind of take that approach in terms of a reasonableness standard. And then you go from there and have a conversation around it. I know I'm trying to really simplify it, but that's really the approach.
I mean, it almost, what I'm hearing, Peter, is like, take the legal side out of it. Like obviously come to you guys to write the legal language, but your guidance would be like almost the golden rule, right? Do unto others what you would want done unto you. And that would be probably reasonable and fair. And then have you and Brent craft the legal language to make it work.
Yeah, if you're a practice owner and you're hell bent on, I need 5 years for an associate, you want to talk to them about it and say, listen, doc, at the end of the day, if you can't solidify your relationships within a year of that associate leaving your practice, what does that say about your practice? You just got to think of it from that lens. That's why 1 year, 2 year at the most, it's pretty reasonable. And Brent said, 24 months, at a max is a pretty good standard. You need to be able to solidify those relationships when that associate leaves and say, listen, in order to bring them back. So to have 3, 4, 5 years in an employment relationship, I think it's just completely unreasonable. And you run the risk of it not being enforced. You run the risk of it going to somebody else, maybe an independent judge, and he or she may say, you know what? Not only is this not enforceable, I'm not going to enforce it on 5 years. I don't think it's enforceable at all. Why would you go down that route and spend that time and money to do it when you can have something that's more practical and it's going to do the job that you want it to do at the end of the day?
So if I were a veterinarian finishing up vet school, moving into industry to try to practice, and I was presented with opportunities, would you recommend me, or I guess them in that scenario, actually go through their employment contracts with someone like you all? Because I feel like there might be a perception of them not being able to afford that kind of service, or is that something that you think is more easily accessible?
I think, again, it's about our education, and we speak regularly. We go to schools, BBMAs, we're in all different types of organizations talking about it and trying to have somebody review it for you. Somebody who's obviously experienced, but have somebody review it so you understand what you're signing. Because I think you're going to spend more money in the back end trying to get out of something, even though it may not be enforceable, like the scenario I raised where our client's looking to do this business venture, but she signed a pretty poor employment agreement, and now she's scratching her head saying, geez, is this or is it not enforceable? Now, how much is it going to cost me to try to get out of this thing? Where if she negotiated up front, I think she would be in a better place. That's one. And two, I think, and Brent, you could back me up on this, it's a different landscape right now. The associate market is so thin, as you guys all know. The leverage has swung over to the associates. We have practice owners bringing on associates now without employment agreements because they're so desperate to get the associate in. They're afraid to have them, even broach the subject. I have one now where he's just testing the market with an associate, bringing him on. He said, well, if it works out, then maybe we'll give him an employment agreement. But right now, I don't even want to do that because he's so desperate to have an associate work.
Wow.
With him. So it's a different market, I think, than it was several years ago because it's so hard. Every conversation we have every day, and I had one at 1 o'clock this afternoon with a client. What does it come up? There's not enough associates out there. It's part of almost every conversation that we're having with clients all over the country.
And that goes back to, we talk about this all the time, and it's building a team of people who are experts and who understand your field. I can just see a hospital owner going to an attorney who maybe they went to undergrad with, who has no clue in the veterinary space and just tries to, propose boilerplate standard employment agreements, not understanding the market dynamics that we currently have. So to us, it goes back to what we always talk about. There's so many good resources within the veterinary space. It's just building a team of experts who have subject matter expertise, who work with people like you, who understand the business. So, I certainly can appreciate that. The value
James, we're having those conversations on a regular basis. It's them lenders, financial advisors, CPAs, and even the attorneys. These are all people that all of us on this call, we're all friends with. And we whether it's us or another law firm, you want somebody within the industry who knows what they're doing. It's only going to protect you in the end. So it's just. And we have that same conversation with the lenders. They go get their friend at, ABC Bank on the corner, and it's just, they don't know what they're doing because they're not in this market where they're better off finding an institutional lender. So yeah, we have those conversations on a day-to-day basis too. I think just educating the clients is what we're trying to do with our other colleagues in the industry.
No, I mean, and I think that to that point, the exciting thing about this, Peter, and really Brent as well. Obviously, Brent, we tapped probably more into you on the legal side of things, but just the perspective of not just being an attorney and reading the legal documents, but being able to wrap that around understanding the industry, because that's really where value can be added. And I think also really where businesses are built and value is created, in my perspective. So I really appreciate you guys taking the time to sit down with us and run through kind of a complex as well as a little bit touchy subject and give us your honest feedback on it. So you guys have kind of navigated this. We do have one final parting question that we ask everybody, and it's really a two-part question, and you'll each have to answer it. The first question is, there's a sign that hangs over the bathroom at one of my friend's houses that says, "Everybody wants to change the world, but no one wants to change the toilet paper roll." So we ask all guests if you always make sure and change the empty toilet paper roll, or if you guys kind of try to slide out and leave that empty toilet paper roll sitting in there.
Brent, you want me to answer that one first? I live with 4 women at my house with my wife and my 3 teenage daughters, and I have a female cockapoo. So I am outmanned over here. I do a lot of changing over here. That's basically, I wear many hats, and changing paper towel rolls and toilet paper rolls is one of my many hats. In my house, that's called TMI, by the way. Too much information.
Yeah, I would say from, my personality is I can't stand to see an empty toilet paper roll, an empty paper towel roll, a full garbage can. If I'm walking by, even if I didn't use it, I got to change it, because otherwise it's just going to aggravate me.
Hey, that makes me feel good to have that level of discipline in an attorney.
Well, yeah, it's probably not good for my mental health, but
Well, you guys can either tag team on the last one or go at it alone. We always do finish on something a little bit easier. What is your one piece of advice, kind of one sentence of advice for veterinarians who want to change the world or change the veterinary industry?
Well, my recommendation.
I guess you could always say, on the advice of my attorney, I choose to not answer that question.
I think that they should just, you're not going to change the world, without changing your own culture and practice. And so, whatever you think is important for the veterinary industry as a whole, make sure you're implementing those ideas and culture in your own practice, even if others aren't. And, you be the leader in that area.
I love it. Peter, you want to follow it up?
Wow, that's a great response. Very professional. I'm glad he's my partner. That's right. Real good. Yeah, and it just embrace the time right now. I think it's a really special time in the industry. I know over the last few years with COVID, a lot of our clients are tired, they're frustrated, but I think it's still a great industry to be a part of. There's a lot of activity, there's a lot of opportunities, and I think at the end of the day, they got to sit back and realize that they really are in a great industry. And I think, if anything, over the last few years with all these corporate buyers coming about, if anything, it's brought real value to the veterinarians, and it's long overdue. They're seeing, their hard work, they're being paid for now, whereas years ago they probably weren't. And it's good for them. And I think they should embrace this and look forward to the future. It's very bright for them.
No, I love it. That's great. Great advice. We really appreciate you guys spending some time with us today. This will wrap up our third part of a 3-part series on employment agreements, non-competes, non-solicits. Travis, I feel like we've been talking about this for a while now. Hopefully we put out some good content. People feel good about it. If anyone listened to this and had questions or thoughts or interested in reaching out, feel free. You can go to the Mandelbaum Barrett website, National Veterinary Law Group. That's the group that Brent and Peter work with. Brent and Peter, thanks again for your time. We really appreciate it. This has been the Vet Worthwhile podcast. Thank you for listening.
Thanks, guys. Appreciate it.
Thanks for having us.
Talk to you soon.
Thanks again for tuning in to the Vet Worthwhile podcast. You can find us online at signaturefd.com/signatureveterinary.
And then our ask would be, if you found this episode valuable, just think of one friend or colleague that you think would enjoy the content, and just please share. So thanks again. We'll see you next time.
Travis York is the owner of 3-in-1 Vet Advisors and a partner of Signature FD. 3-in-1 Vet Advisors is a veterinary consulting and strategic planning firm of which Signature FD has no involvement or ownership. James Yost is a partner and wealth advisor at Signature FD. Signature FD is an investment advisor registered with the U.S. Securities and Exchange Commission. 3-in-1 Vet Advisors and Signature FD are not affiliated. Mr. York provides all non-investment advisory services through 3-in-1 Vet Advisors. The opinions of the guests and the contents of this podcast are intended to be educational only and should not be relied upon as investment, tax, business, or planning advice. You should consult with a professional advisor prior to taking any course of action that may impact you or your business.